Welcome to Direct US Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. I am an immigration attorney with almost a decade's worth of experience, and today we're going to talk about what to do if an H-1B holder has been laid off from their job. Stay tuned. Layoffs for H-1B holders can result in tough times because there is limited time to find a new employer to file a new H-1B petition, apply to change status, or depart the United States without violating status. Now, there are 7 things that you should be aware of. First is seeking new employment sponsorship. So the primary purpose of an H-1B visa is to work for a specific employer in a specialized occupation. After a layoff, the H-1B holder may actively search for a new job with another employer willing to sponsor their H-1B visa. The new employer would need to file a new H-1B petition on behalf of the individual before they can start working. That petition must be received by USCIS prior to the 60-day grace period expiring. Number 2 is H-1B portability. If the H-1B holder finds a new job with a different employer in the United States, they may be eligible for H-1B portability. This allows the worker to begin working for the new employer as soon as the new H-1B petition is submitted to USCIS without waiting for the approval. However, certain conditions must be met, and it is H-1B specific with respect to whether the new employer is a CAP subject or CAP exempt employer. Number 3 is the grace period. USCIS provides a grace period of up to 60 days for H-1B visa holders who have been laid off or terminated from their employment. During this period, the individual can remain in the United States and explore new employment opportunities or even new visa options, or make necessary arrangements to depart the country. Number 4, change of status. If the H-1B holder cannot secure new employment and is eligible for a different non-immigrant status, they might consider applying for a change of status. For instance, they could consider changing to a B1, B2 tourist visa, an F1 student visa, or another suitable visa category. Number 5 is the green card, either through an adjustment of status or through consular processing. So if the H-1B holder has an approved immigrant petition, which is Form I-40, with an immigrant visa number available, or is eligible for a green card based on a family sponsorship or another category, they might consider applying for a green card to become a lawful permanent resident. The applicant may do this while inside the U.S. through an adjustment of status or outside of the U.S. through consular processing. Number 6 is H-4 dependent status. So if the H-1B holder's spouse also holds H-1B status, the laid-off individual might consider changing their status to H-4 if they meet the eligibility criteria. Depending on whether the spouse also has an approved I-140 will dictate whether the H-4 visa holder may apply for work authorization. And number 7 is returning to the home country. So if none of the previously mentioned options are feasible or desired, the H-1B holder may consider returning to their home country after the layoff. Be sure to maintain lawful status during the grace period and make the necessary travel arrangements. It is important to note that the employer is required to pay the reasonable fees for a return ticket to the visa holder's home country. Overall, it is essential to consider the specific circumstances, immigration history, and the future plans before deciding on your course of action. Now let's talk about understanding the availability of the H-1B visa grace periods and unlawful presence. So there are circumstances where the H-1B grace period is not fully granted by the Department of Homeland Security through USCIS. The grace period can either be shortened or completely refused due to fraud, unauthorized employment, or criminal charges. If the visa holder is outside of the grace period and is still physically present in the U.S., the visa holder will start accruing unlawful presence. If you accrue more than 180 days of unlawful presence, but less than a year, then you will be barred from re-entering the United States for 3 years. If your unlawful presence exceeds 365 days, you will be barred for 10 years once exiting the U.S. I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.